faculty, staff, and all the students present here today. I, Saraswathy Vaidyanathan, am pleased to welcome you all today to our campus for this focal panel discussion on 20 years of product patents in India. Innovation drives progress.
I am unable to hear the voice from the stage.
Sir, am I audible now?
Now I can hear.
Innovation drives progress, and the legal frameworks that support it are the tracks on which it moves. Today, we come together to celebrate a milestone in India's intellectual property history. 20 years since the launch of our product patent system. This path has transformed industries and ignited important discussions. We are fortunate to have some of the brightest minds in the field to lead us through this conversation. To commence our event on an auspicious note, let us turn to the timeless tradition of lighting the ceremonial lamp. I invite our panelists, Dr. Soni, Dr. Davinder, and Professor Prabhakar to please light the lamp. Yes.
Recording in progress.
I now take the opportunity to introduce Professor Davinder Singh. Professor Dr. Davinder Singh is a professor at the School of Management at BMU and the CEO of ACIC-BMU Foundation. He also serves as the in charge of the Incubation Center at BMU. I invite him to share his thoughts to kickstart today's discussion.
Professor Dr. Shri Unnat Pandit ji, Professor Dr. Biswajit Dhar ji, Ms. Chetali Rao ji, Ms. Shuchita Sen ji, Dr. Sunit Soni, colleagues of the faculty from various schools, students, ladies and gentlemen, good afternoon. It's a pleasure to hold this IP panel discussion today. It's been 20 years since India started product patents. Of course, patents and IP existed in India before that. And when we, at ACIC, when we heard about this being organized by School of Law, we felt that it's only natural for incubation to get involved. And my few minutes that I will speak on is why is this important for us. We all know that patents are a way of capturing and creating value. Patents are a way, it's been kind of a signified, authorized, or kind of put on record, and significant innovation has happened, something which has not been done earlier has been done now. That is in itself a very important thing, but the key thing is that that signifies there is a value in it. There's a protection required for that value. And that is something where universities are actually a breeding ground, fertile ground, because a lot of research done by the scholars, and that scholars include not just the faculty, but even the PhD students, and many a times, even students of earlier programs earlier than PhD are involved in creating something which is new. So universities do create new knowledge, and that new knowledge needs to be recognized through various IP mechanisms, not just patents, but many other copyrights, and at times through design patents as well. It's very heartening that university like BMU, which is very young, we have had a fair amount of work and output coming out of the university in the areas of patents. Over 30 patents, 15 patents have already been granted, another 7 design patents have been granted, 80 plus patents applications are under process. Now that's just at the university level where the academics are involved. Now also interestingly, at the incubation level, we have a lot of startups which work with us, with the university, with the incubation at the university. And these startups have also generated their patents. 35 product patents have been registered by various startups of the university incubation system. They also go beyond technology patents. Being a business enterprise, these startups also register trademarks. Okay. Now, many a times we may not understand the value of a trademark, but it's an important thing. I mean, if I were to tell you, please drink this glass of water, some of you may drink it unhesitantly, but some who don't know where this water is coming from, you may hesitate. But if I were to offer you a bottled water, which has a brand name like a Kinley, Bisleri, or Aquafina, chances are most of us would not even think twice and go ahead and kind of accept that water as a safe drinking water. Now that's the power of trademarks. Now this coming back to the patents that have been generated, university patents are still at non-commercialized, most of them. We want them to be commercialized, and the reason for that, because when we look at the startup side, the 30 plus patents which startups have with 20 trademarks, the combined valuation of these startups is over 500 crores already. And not that this 500 crores is coming entirely from the patents or the intellectual property they have, but a fair amount of that valuation is coming from having a certain IP. Same thing goes for even established companies. You know, I worked in Coca-Cola for a long time. The combined asset value on the balance sheet of Coca-Cola company was much smaller than the market cap of the company, which means people are willing to pay more than the physical assets that the company owned. And the one why they were willing to pay more was simply because of the kind of trademarks that the company had, the kind of ability they had, those trademarks had, of generating value over a period of time. Now this is the important thing. When we talk of patents, it's not just to protect something which has been created, but eventually a mechanism also to unlock that value. And this is where I think panel discussions like these, work done by university and the incubation in conjunction with each other works a lot, because one of the things that we would like at the university is not just to research which ends up into a publication or a patent, but actually a research which goes and creates a value. Now, while I spoke about this value, one thing I spoke about was the economic value. But that's not the only thing we are worried about or concerned about. Many of these patents have an ability to create a social impact. Now, if a little while ago we were having a discussion, there are a lot of drug discoveries, there are a lot of new systems, there are a lot of new technologies which may not necessarily just derive economic value, but could actually create a much better society for all of us to be in. And a better society and a bigger society and more prosperous society eventually does give economic benefits. But before that, the social benefit has to be put onto a priority. And some of this work can also get facilitated through commercialization. And by commercialize, not just about commercialization through the normal way, but to see how can the society at large. Now, so one of the things that we would like to do as we go forward in future at the university is to look at how do we unlock the value of the patents that we are creating, the IP that we are creating, one, in terms of economic benefits, two, in terms of social benefit. And third thing that we are also looking at is how does it relate to the overall SDGs and therefore a better planet to live in. So hopefully during this conversation that we will have today, we really look forward to finding some thoughts, some ideas for all of us to take back and think about as we go forward in this journey. I once again thank all the panelists and especially Dr. Unnat Pandit for taking time out and being with us today. Thank you so much, sir and ma'am.
Thank you, Professor Singh. The year 2005 marked a key turning point for India's patent landscape. The amendment to the Indian Patents Act, which fully adopted project patents in sectors like pharmaceuticals and agrochemicals, was a commitment to the TRIPS agreement and a step into new era of intellectual property. Over the last 20 years, this transition has been met with both applause and apprehension. It has been lauded for fostering a R&D system while also raising critical questions about access to essential goods, especially medicines. How has this regime truly impacted Indian innovation? What have been the socio-economic consequences? These are some of the questions that we are here to explore. To provide a comprehensive overview and set the tone for our discussion, we have the privilege of having with us Professor Dr. Unnat Pandit as our keynote speaker today. Dr. Unnat Pandit is a professor of IP, Innovation and Entrepreneurship at Jawaharlal Nehru University. Dr. Pandit has been very closely involved at every stage of conceptualization of the IPR policy of India. His current position as the Controller General of Patents, Designs and Trademarks at the DPIIT Government of India is a testament to his seminal contribution to IP rights in India. The former dean at Atal Bihari Vajpayee School of Management and Entrepreneurship in GNU, Dr. Pandit has also been the program director of Atal Innovation Mission at Niti Aayog. In addition, Dr. Pandit has also served as an officer on special duty, deputed to the Commerce and Industry Minister, Government of India. An interdisciplinary exemplar, Dr. Pandit seamlessly operates between academia, industry, and bureaucratic roles in building the Indian IP, innovation, and entrepreneurship ecosystem. Now, I invite Dr. Pandit to deliver the keynote address. Sir?
Thank you for the introduction. And it is indeed a privilege. And again, I feel that I have missed the opportunity to join you in person due to some challenges with the 11th hour meetings which has been called. I have missed this, but my apologies. I would have joined you in person, but somewhere I am not fortunate enough to visit the campus in person and meet and discuss some of my thoughts with each one of you. So, but one thing for sure, which is a unique initiative, I appreciate the Devendra Singh ji and the team of BMS Munjal University for the command number work which we are doing in the Atal Community Innovation Centers, and also nurturing the innovative minds to create the IP driven solution. And I'm told that you have quite a big number of patents which you have applied, and few of them you have also got granted. and still the journey is on. So while journey is on, today a special day which you have marked on a 20 years of a product patent in India, I would like to share some of my thoughts. When the product patent regime which has been introduced in India as part of the TRIPS provisions which India has enacted to 1998 with the retrospective effect in 1995, and that was allowing the newly joined countries into the TRIPS agreement to avail the 10 years of a flexibility. Of course, this might be a history, but this sets a context. I want to share my thoughts as part of a Doha declaration on TRIPS, and specifically in a public health. This was the need of an hour that we enable all these provisions for the country to serve the society, to serve the nation, which can be built on the foundation of a creativity and innovation. From centuries, we are an innovative country, and we don't need to prove that. Zero is also one of the key inventions, and several such inventions, innovations, which our researcher have done it. चाहे वो पुष्पक विमान ही क्यों नहीं हो. So Indian knowledge system is such a rich knowledge system, which has the key foundation of IP innovation. But that's not the topic to discuss, so I won't go much into this. But this opportunity through which we have gained, that has set a new dimension, a new standing position to see the IP regime got introduced in 2005 by way of a Patent Amendment Act 2005, wherein an important provision of protection through a product patent got introduced. And it is irrespective of a various field of invention on technologies, like for drugs, food, chemicals, mechanical. So this kind of exclusive right, this provision was introduced. And such a product right has also, initially it was thought that this is not in favor of the industry. So initially the industry's response was negative on the IP right. So we are not having too many patent applications by the Indian researcher. More than 85% of a filing was from the foreign applicant to protect their IP right in India for better commercialization opportunities. And very few Indian researchers who wanted to protect their research in India. TRIPS has enabled us a robust and equitable IP regime. So without any kind of a discrimination, the thing which the domestic applicant is getting, that made accessible to that extent for the foreign applicant also. Like we have a globally competitive criteria for assessment of a novelty, inventive step, industrial applicability. And beyond this, we have introduced TRIPS Plus provision, wherein India firmly believes that we will not allow the evergreening of the IP right. To stop this evergreening of the IP right, Section 3 has also been introduced, which talks about the non-patentable subject matter. If I may compare the Indian patent systems with the US and Europe, which is the most advanced IP ecosystem as on date. Then the US, I'm sure you are aware with this SWORD. So US IP ecosystem, I'm comparing with the SWORD that it has a singular side edge. That means they have a single mode of assessment of a novelty, inventive step, industrial applicability. And they have clarified in their act, rules and manuals whether the IP is protectable or not. That will be reviewed purely based on this merit, which is the global standard also. So anything and everything which somebody wants to protect, if they have passed through this SWORD, they will get the IP right. It may not be a perfect example, but by the time I will complete this, you will have absolute clarity on this. So imagine with the non-technical example of a sword which has a singular sharp edge, and when this is operated, if some application is passed through this, it will get a protection. Now let's imagine to the European system, which is much organized and much clarified system and little bit stringent also. So the way the broad claims which is granted into the US system, the way the application which is dealt into the US system, Europe is having a more strict and more classified systems to evaluate the novelty, inventive step and industrial applicability. So with the same sword, if you can see that it has a sharp knuckles, so then the criteria for assessment of a novelty, inventive step and industrial applicability is more sharp. So you may not get the broad kind of a claim which is there in the US system, but generally you need to be more conscious and gear up to get the patent in Europe. Now in India, we equally have the similar sharp edges, because traditionally the Patent Act is derived from the even before independence. In 1911, the Patent Act for India got enacted by the Britishers. In 1912, the Patent Office headquarters was notified into the Calcutta. And then after independence in 1958, the headquarters was notified to Mumbai. And in 2025, now the headquarters is notified to Delhi. So it has a long history. And maybe we have already completed the 100 years, but now we are talking about the 20 years time gap, through which we have seen the drastic change in the IP regime. But for understanding this change, it is very much having relevance to understand the history of our IP. And that's why the single side edge in US system, the sharp edge into the European system, and in India, the seed was already introduced in 1958 in Iyengar Committee report for utilizing the IP right for the country and for the benefit of society. So the commercialization was already seeded in 1958, and that has been implemented in 2005, wherein the invention is not working efficiently, or it is a me too kind of an invention, or it is quite an obvious to the person skilled in the art and do not enhance any significant improvement into the parent invention, that cannot be granted as an invention. Besides that, we were having a significant focus on our agriculture system. So agriculture related invention, the medical treatment related invention, computer related invention also, because not as good as in other countries about the IT. Now we are dominating as a number one country in IT service provider, and consistently we have maintained this situation. So section 3 was introduced, which defines the non-patentable subject matter. So again, I am going back to that swords example. So like Europe has the angular sharp edge on one side, we have a double side. So application filed in India has to pass through both the tests, the patentability test, and it should not fall under the ambit of a non-patentable subject matter. The objective was to allow the genuine invention. That doesn't mean the inventions which is granted in US and Europe are not genuine. But we truly believe that invention should have the demonstration of a enhanced efficacy. The combination should not be a me too kind of a combination. It should offer a resulting effect which is better than the individual compositions. So all these were well defined, and these aspects were well adopted by other developing world also. So this is a resulting effect. After 2005, we have drive the IP narrative into the developing world, and in global South, majority countries are having alignment with the Bharat's position even in WTO, in World Intellectual Property Organization. So stable and effective legal framework we have provided through this 2005 Patent Act amendment. When we have got the patent product regime introduced, we were getting a less than 1,000 application filed, and roughly around 500 patents were getting granted. From 2005 to 2014, let's take a 10 years of a gap. So from 1,000 application to at least we reached to around 20,000 applications. And from 500 or 600 applications getting granted as a patent right, it reached to 6,500. So sharp growth we have seen in 10 years. Now let's take this example and study the industrial revolution which has happened. See the pharma which has grown from 2005 position to 2015 position. India were having highest number of a US FDA file, DMF filing. API supplier, India was leading into this. Formulation supplier, we have started gaining our position, and way ahead to other developing world, we were in the position of becoming the global pharmacy. And by 2014, 15, 16, we have established our position to be a key leading player in the pharma sector. In IT services sector, again, we have gained a lot. Many Indian companies like Infosys, TCS, Mahindra Tech, they have established their positions to become a key player, global player in IT sector. In 2016, government has introduced National IPR policy, which has strategically defined 7 objectives. And maybe there are several researchers into this audience. I would make an appeal that you should study all the progress which has been made so far based on the recommendation given in the 2016 policy and what has happened in last 9 years of policy. We are one of the active member of a World Intellectual Property Organization. We are sixth in the largest patent filing in the world. We are fourth in trademark filing. We have a highest number of a design filing growth. Indian, of course, the copyright sector is not a formalized IP protection. We have a important creative work which has been produced by the creative industry. Indian GIs, Honorable PM is the ambassador of GI. And now it has been well accepted. The same fame which was been given to the basmati rice, equally the other GIs are also getting the same name, fame and popularity, and it has a craze among the community. So overall impact of IP rights got amplified. That shows that the product patent regime which got introduced, the decision of introducing with the retrospective effect of a 1995 and taking the 10 years of a full advantage and the growth which has happened during the 10 years is remarkable. The second leapfrog jump or maybe a pole vault jump came in 2016 while National IPR policy got introduced. The IP as a primary growth engine was got established in 2014 when the IP think tank was formed. 2016, within 18 months, the policy got approved by the Union Cabinet. If we study even the national IP policy or a strategy paper, none of the country could able to achieve this in such a record time of 18 months. So this is one of such. The Startup India initiative, the Atal Innovation Mission are the product of this kind of a recommendation which has been given into this policy. Even before the policy gets approved, several initiatives has been taken up. In 2017, 80% of a reduction in the fee structure for formally protecting your IP right has been introduced. So all the academic institutions, all the small medium enterprise, all the MSME, all the individuals, all the startups can file for protection of their IP rights with minimum 80% of a reduced price. So that has again given a boost to the Startup India, given a focus to the startups to think on the technology driven IP development. Now as a result of these kind of seedings which has been introduced in the form of a IP as a catalyst, now we are one of the fastest developing startup ecosystem with more than 100 plus unicorns in last 5-7 years. That's the impact which such policy interventions have made it. And it has been passed to the small applicant also. It has modernized the entire IP culture. It has offered the IP education awareness. You maybe in your university the kind of awareness which was there 5 years down the line, just immediately after the COVID when the ACIC was approved, and now the kind of awareness which is there in your university, the temptation which is there among the students and the faculty, there's a wide difference. That is something which is the change which has been brought in last 3 years. In 2024-25, around 1,03,000 got granted. 1,10,000 patent newly applied. So it is not just in grant, new application also. 75,000 requests for examination which we have received. So everything is catalyzing into building the strong IP regime in the country. The simplification which has been done in last 11 years, 9 times government has amended the patent rules to make it more ease of doing business and ease in IP protection in India. More sectorial focus centric. Simplification has been done. This benefit to the stakeholder has been the prime focus for the amendment of a patent rules. Whether it is a pre-grant opposition, whether it is a working statement requirement, catalyzing the commercialization of IP right, seen. That gives the IP is the key to open the doors of a technology and knowledge embedded economy. It's a high time that we encourage the IP creation, commercialization and its effective utilization. Sustainable development goal may be one of the focus area on which we need to encourage the IP creation. Because if Bharat need to become a Viksit Bharat by 2047, ASAP will address the SDG challenges. Whether it is on a hunger, whether it is on a poverty, whether it is on a health or water, sanitation, all these aspects we need to address. And we have to cater the population of 140 crore. So each citizen has a right to have the access of technology. How we can ensure that this technology is reaching to each mile. Fintech sector. Again, the UPI penetration which has happened in last 5-6 years is a classic example. In 6 years, we are dominating 46+ percentage of a digital transaction happening in all across the world through UPI only. See the way we are encouraging the IP driven economy. It is a classic example. National Payment Corporation of India has got 4 patents on the UPI. But now see the impact of this patent. It is offering a solution which is most secure in the world, which is fastest in the world, and which is providing end-to-end terminal support within fraction of second. And I don't need to prove before you, because in this hall nobody would be there who has not done UPI transaction. And Google Pay has a different application outside India. Google Pay is operating on a UPI. WhatsApp Pay is operating on UPI. Amazon, they have a AWS, but their payments are made on UPI. Even domestic company, Paytm, PhonePe, PayZapp, all these applications are operating on UPI. And I'm sure you might have experienced that we have minimized the utilization of a debit card or credit card for making a payment. And it is such a user friendly that we can just from mobile, and with mobile we don't need even wallet. So that's the power of a technology who has made the lives simplified. And patent has played an important role here. And this is possible because the IP design was a societal centric. COVID application, vaccine, the way the patent, vaccine certificates got delivered to each and every person who has adopted the vaccine or taken the vaccine shots. The kind of a data from which center, which vial, who is the person who has administered this vaccine, and from this vial how many people got the vaccine shots, whether any other adverse event complication which is there on day 1, day 3, day 7 or not. And by the day 7, if no complication is reported, this certificate is delivered to that application and to the person. See the way even the big developed innovation ecosystem could not able to do. In US, it was taking a manual certificate issuing that would have taken 3 to 4 months for a person who has taken the vaccine. And we have 200 crore doses which got administered, and for each and every dose we have the data. And to that an extent, see the power of intellectual property simplifying the lives of citizens of the country. This is the impact this mindset got created in this 20 years of a Patent Amendment Act journey. See, after COVID, the kind of a sharp increase which has been observed in patent filing. So, during the COVID, the innovators not sitting at home, they were working on new innovations. They were working on filing the patents, defending patent. That kind of a jump, which is something which is unprecedented. And today we are celebrating that success. 20 years of a Patent Amendment Act, introduction of a product patent regime, from a mindset of anti-patenting to the pro-patenting country, patent-friendly country. And it has boosted the economic growth also. And for next 2 decades, India aims to become a technology and knowledge embedded economy. IP is key to drive this. And like Devendra Singh ji has mentioned that academic institutions are the hub of IP creation. It's our duty to encourage the students, our duty to apply our intellect in driving this IP design, designing the solutions which has IP creation is one of the focus area. भारत विकसित भारत बनेगा तब 2 दशकों में हमारा क्या कंट्रीब्यूशन रहेगा as an individual, as academician, as a researcher, as a university, what we are aiming to contribute in the journey of Viksit Bharat. And for students, what you are aiming, how the Viksit Bharat should be. यही समय है, सही समय, जो प्रधानमंत्री जी कहते हैं ना, यही समय है, सही समय है, अपना लक्ष्य तैयार कीजिए। to give you an opportunity to think or realign your goals, visions, objective. And we should thank the local organizing team and ACIC who has done or planned such a wonderful event. I am sure you will best utilize this opportunity. The eminent panel will also help you addressing your concerns, queries. And with this, I take a pause. I know I have taken more than the allotted time. But I have thought that this is something which is required to reset the goals, tune the research mindsets. And that's why I have thought of let me take a liberty to take 5-10 minutes more and conclude my speech with some realigning the thoughts. That is something which is required. And I'm sure this will give you one more opportunity to live for the country. प्रधानमंत्री जी जो कहते हैं ना, हर किसी को मरने की आवश्यकता नहीं है, देश के लिए जीने की आवश्यकता है. तो आने वाले 2 दशकों में हम कैसा जिएंगे जिससे कि हमारा अस्तित्व देश के लिए काम आ सके. With this I take a pause. Thank you very much. Namaste.
Thank you so much, Dr. Pandit, for your elaborate address. Your insights have not only covered the historical arc of our patenting system, but also to give us a very detailed update about what has happened in the last 2 decades. This address has actually laid the perfect foundation for moving on to our next session. So we now move to the core of today's event, the panel discussion. But this panel discussion is not just an academic exercise in looking back. It is, in fact, a vital conversation about our nation's future. As Dr. Pandit rightly pointed out, India is charting its course towards becoming Vikasit Bharat by 2047, a developed nation on the world stage. One word that stands out as the primary catalyst is innovation. And as Dr. Pandit pointed out, IP is the key to open the doors of a knowledge and technology-driven economy. It is actually fascinating to think about this timeline. We are here today reflecting on 20 years of product patent regime, assessing the journey so far. And it is the next 20-odd years that will define our journey towards the Vikasit Bharat goal. To dissect this crucial link between our patent laws and our national ambitions, we have an exceptional panel of experts who I would now like to introduce. Our first panelist here today with us is Professor Dr. Biswajit Dhar. Our development economist by training, Professor Biswajit Dhar was a professor at the Center for Economic Studies and Planning in Jawaharlal Nehru University. As a former Director General of the Research and Information System for Developing Countries, Dr. Dhar was instrumental in the establishment of the Center for WTO Studies. Professor Dhar's experience in treaty negotiation vis-a-vis World Trade Organization, the World Intellectual Property Organization, the UN Framework Convention on Climate Change, and the Convention of Biological Diversity highlights its wide grasp of matters of policy. Dr. Dhar has also served on panels and groups advising the Government of India and other organizations such as WIPO and the WHO. Professor Dhar currently serves as an advisor to the Asia-Pacific Research and Training Network on Trade of the UN Economic and Social Commission for Asia and the Pacific, and is on the governing board of Inter-University Center for IPR Studies of the Government of Kerala. We welcome you, Professor Dr. Dhar. Our next panelist is Ms. Abhilasha Nautiyal. Ms. Nautiyal is a partner at ERA Law, New Delhi. She is a commercial disputes resolution lawyer practicing primarily at the High Court, District Court, and tribunals in Delhi. Boasting of clients such as Nokia, Choice Hostels, Network 18, and Brown Foreman, among others, Ms. Nautiyal is an expert in IP litigation and mediation. Her areas of expertise include IP licensing, competition law concerning patents, and IP enforcement. We welcome you, Ms. Nautiyal. Our next panelist is Ms. Chetali Rao. She is Senior Scientific Researcher and Legal Advisor at the Third World Network. Ms. Rao is a highly experienced lawyer and industry expert. As a dynamic practitioner, Ms. Rao is an expert in multiple domains such as intellectual property, global health, international trade law, biodiversity, and traditional knowledge, to name a few. Ms. Rao's long professional career reveals an interdisciplinary approach combined with rich multicultural experiences that attest her expertise as strategist across all organizational levels. We welcome you, Ms. Rao. Lastly, we have Ms. Shuchita Shah. She is a registered patent agent and senior manager in EnnoblelP. Ms. Shuchita has more than 15 years of experience in specialized patent support services. Specializing in patent searches, Ms. Shuchita is well acquainted with all the possible permutations and combinations to navigate all the free and patent databases. In her present role, she helps researchers and innovators navigate the Indian patent procedures and patent searches while educating fresh graduates on the nuances of IP knowledge. We welcome you, Ms. Shah. With that, I would like to invite the panelists to the dais, and we can start our session. All right. So this panel discussion, as we talked about, is going to be about not only reflecting at what has happened, we are also going to understand where we stand today as a nation with our patenting system and how do we go forward from here, considering we have multiple government initiatives and a goal that is Viksit Bharat. So I would like to start with you, Professor Dhar. Given your active involvement when we were transitioning from the process patents to product patents, could you share your experiences of the adoption of this product patent regime?
Yeah, thank you very much, and it's a pleasure to be here, and thank you BMU for inviting me. It's a very interesting discussion. And it's a matter for me, in a way, to reflect on what happened earlier and the whole process of amending the Patents Act, because several of us were intimately involved. Okay, in the process of amending the Act and in the interactions that went on within the government and outside, with the WTO, and how to make our Act TRIPS compatible. Now, the one important issue, and I think as students of IP and technology, we must understand, is that a patent system actually reflects a fine balance between the rights of the inventor and the interests of the public at large. And it's very important to also understand that it's a public policy objective to reward the inventors, but like any good law, there has to be a balance of rights and obligations. And the important thing is that, like for instance, if you talk to the big pharma companies, they'll always talk about the important innovations, the new drug developments that are taking place, which is, of course, very important. New cures are coming out of it. But the important issue is how many people are getting access to those medicines. Yeah, that's a very important public policy objective, because if the public is protecting the inventor, then the inventor has the right, has the obligation to give something back to the society. Because that's how the patent system developed. Because, in the absence of a patent system, and as economists would tell you, that there would be no incentive for innovation. Because if someone, developed an useful product or a process, and had that just put in a market, which is, an open market, a freely competitive market, anyone would have picked up that invention and then developed further on that invention and made money out of it. The inventor, after having spent whatever, millions or billions, would have got nothing out of that investment. So that is the key, that, it is an important public policy perspective, objective that the patent system has. And when we actually we didn't go into this product patent system willingly, because we were pushed into it. The TRIPS agreement was entirely drafted by the advanced countries. They're still trying to push the contours of the patent system to make it more friendly for the rights holder. But what happens to the public at large? That's, of course, an issue that has to be discussed, and and students and the public policy people need to reflect on that. So we were in a situation where we had a very, upcoming generic pharmaceutical industry, and this was providing medicines to our people at possibly the cheapest rates in the world. And we saw that, a product patent coming in, and we had a process patent. We didn't provide, patents to products, but only processes. And Dr. Pandit mentioned about the Iyengar committee, and all students of IP must read that report. In fact, I was just refreshing my memory by looking at it in the morning, this morning. And what Rajgopal Iyengar, Justice Rajgopal Iyengar had to say about the importance of a process patent for a developing country. And I think it was very important for us at that juncture. And that industry was developed. So the pharmacy of the world didn't come out of nowhere, what Professor Pandit was talking about. It came out of the fact that we had a fairly flexible patent regime, not providing product patents, and that enabled our the companies to get into the market. And mind it, there's a lot of allegations that are made that they were copying. Now, as a student of technology, I can tell you, imitation and innovation are two sides of the same coin. You could never have had innovation if you didn't imitate. Because, see, again, you look at history, it's very important to look at history. Innovation, sort of industrial revolution took place in only one country. And the rest of the world copied. So it went to Europe, then it went to America, it went to across the other part of the world, to Japan, Korea, China. So they're all doing this, yeah? Therefore, it is important to recognize that what are companies that are fundamental tenets of the TRIPS agreement itself. The principles and objectives of the TRIPS agreement talks about the balance of rights and obligations. Yeah. So what did we do? We said, okay, we recognize the fact that companies are spending whatever billions today. The pharmaceutical companies tell us that they are spending 2.6 billion to produce a new molecule. So if they are doing that, then they need protection for their investment, to recoup their investment. But at the same time, we have to ensure that they get the protection for only 20 years and no more than that. Because the TRIPS agreement also resulted in an extension of the patent term from 14 years to 20 years. And this happened because the companies were saying that they were not getting enough time to recoup their investment. Yeah. So then we said, yes, the section 3D that he talked about, that we said that there would not be any evergreening. You would get a patent for a new product because we recognize the invention, and therefore you'll get product patent for 20 years. But if you just do minor tinkering, yeah, and then come out with, say that I want another patent for a minor innovation, you're not going to get that. So no evergreening. And I was actually reflecting on the 2 weeks back, I was in Kochi, again delivering a lecture in honor of Justice V.R. Krishna Iyer. Yeah, and there's a lot of discussion that we keep having. Students here may not have actually read the Patents Act properly, but Section 3D. And so where did this language come from, Section 3D? And I was actually, from my own experience and sitting with Justice Krishna Iyer, it was that legal luminary actually who sort of gave us the ideas as to how to draft that article, Section 3D, and it came from there. It's very important to actually see how beautifully this thing is drafted, so that there's no evergreening. So that was one thing that was done. Then the second thing that was done was, of course, that patents are granted, and as I said, that there should not be any abuse of monopoly rights. Of course, again, your students here will, those who have studied already the IP paper, they would know that there's always a controversy, and it's going on for a long time. Is patent a monopoly? I won't go into the details of it. It's a fascinating discussion. You must actually see it. A lot of US courts, both circuit courts and the Supreme Court, actually dwelled on this issue whether patent is actually a monopoly, and whereas all of us have different opinions about it. But fact is that there is a company which has a right over product, charging whatever price. Today the most expensive drug on the market, if you convert it into Indian rupees, it costs 35 crores for a course of treatment. 35 crores. Yeah. And so obviously there is abuse of monopoly power that is going on. Under no circumstances a product can be that highly priced. So we did what we did in our Patents Act, and with Dr. Pandit in reflect on, is a compulsory licensing system. And we wanted to put that to ensure that prices of medicines don't go out of control. And if prices of medicines are excessive, then any Indian company which is willing to produce in India will be given a license to do that. Yeah? And these are the sort of safeguards. Like I said, that if you have rights, you have obligations, and then if you don't follow the obligations, then of course there are safeguards. Now, so the several again, now what is so it's very important for us to see whether the 20 years that have passed by and implementing this Patents Act, and which has been taken up by many developing countries as a model act, yeah, how have we implemented it? Because one thing is very sure, and having been part of the government, I know it very well, that we are very good at making laws. Again, many of these kids in your department will be good lawyers. They'll be drafting very good laws. Huh? And all of you are lawyers. I'm not. And but the problem is, when good laws get implemented, yeah, the good laws become very bad in terms of implementation. A classic example, of course, is the Patents Act, the amended Act. Now, we said we're not going to be no evergreening, which means that there would be no, sort of secondary patents, as we say. And we did a study, together, Chetali, and we did a study looking at the grant of product patents in pharmaceuticals for about 14 years, from 2009 to 2005 to 2019. And to our dismay, we found that almost 80% of these patents granted in pharmaceuticals were secondary patents. And there was no business to be granted patents. So what we did not want, evergreening, and the patent controller himself says that it is there. I'm not belaboring that point. This actually happened. So there are on many accounts the patent, and I'm again not getting into details. But the final thing that I would like to say is what his main focus was on innovation. Now it's true. Again, as I said that, as a student of innovation, I would actually, sort of talk about innovation till the cows come home. But the point is, how much are we doing in terms of innovation? Because patents, are a way of ensuring that your innovation is secure. Yeah. The question I would ask is, do patent numbers show how much of innovation is taking place in this country? And there've been tons of studies which are available to say that patent numbers are a very poor indicator of innovation. And one example, the classic example, is China. China is the largest patent office. They actually have 15 lakh patents every year, at least maybe a little more now. And if you look at the quality of patents, many people are talking about it, it's actually horrendous. Yeah? Of course, it's not that China is not making progress on the innovation front. It is, but it's not commensurate with the number of patents that are applied for or even been granted. Now, our patent numbers suddenly have gone up to 1 lakh. We don't know. We're still trying to scratch our heads to find out how these numbers went from about 60,000 to 1 lakh in 1 year. But the important point that I would try to make here, or like to make here, is that innovation ecosystem needs fine-tuning and needs a lot of fine-tuning, I would say. There are lots of isolated pockets. Like there will be, Professor Singh is heading this incubation center. There are a lot of universities have these centers. They're doing the innovation. Are they linked with the industry? Are their innovations, that their technology that they're developing, are they being commercialized? Like he said, there's value. Are we realizing the value? Or are we making enough efforts to produce enough valuable inventions? Now, I'll just give you one number, and I'll do two sets of numbers, and I'll finish here, which is to say that I was just looking at the one indicator that we use to look at how much a country is spending on R&D, and which is R&D as a proportion of GDP. R&D to GDP, and we peaked in 2008, not long after the product patent was introduced, and that was 0.85 our GDP. 0.85% of our GDP was spent on R&D. Okay, and if you look at from there on, there's been a decline, and we don't have numbers beyond 2020. 2020, that figure was 0.64. Yeah, so it's been a steady decline from 0.85 to. Now, a country like Israel is spending 4%. China is spending in excess of 2%. Yeah, and all of them are actually going up. They're being increasing steadily. India has been going the other way. The other thing is that we are becoming increasingly technologically dependent. And one indicator of that thing is that how much are we paying for foreign technology and how much are we being paid for our technology. So there is a Reserve Bank of India has this number. It's called charges on intellectual property. And the charges on intellectual property, if you see the net charges on intellectual property, it's consistently increasing, and in the past 7-8 years, it's more than doubled. Yeah, that if my memory serves me right. So we are consistently talking about transfer of technology because we don't have enough useful technologies. Wherever we go, we're talking about transfer technology. I think we need to, make enough efforts in our innovation ecosystem, produce useful inventions, and which are then protected using the patent system that we have. Just by strengthening the patent system, we are just putting the cart before the horse. Yeah. Right. Now we argued at one point that now all the countries have adopted the TRIPS compliant patent system, including the the low-income countries. So does it mean by adopting the TRIPS system, the low-income countries in Africa, they have become huge innovators? No. They can't become innovators unless they have an ecosystem, innovation ecosystem. And that's the problem that we face today. When this innovation, the innovation policy that he was talking about, Dr. Pandit, I was in conversation with our then Commerce and Industry Minister, Nirmala Sitharaman, who happens to be my college friend. And we then were discussing how to make it more robust. But Nirmala Sitharaman put that place in 2016-17. 2 years later, she was off that post. She went somewhere else. So the entire initiative that she had taken went into someone else, and things have actually not happened. So the short point I'm making is that we have an extremely useful, very robust patent system, which is suited to the needs of a country like India at our stage of development. We need to use this system in order to ensure that the innovators are rewarded suitably, and the public at large is also rewarded for also gets advantage or gets to use the fruits of the innovation. The classic example is access to medicines. I'm sure Chetali will talk more about it, so I won't actually dwell on this. But thank you for your attention. Thank you very much.
Thank you, Professor Dhar. Some very interesting insights with respect to law on paper and law actually in action. On that note, I would like to move to you, Ms. Nautiyal. Given that Dr. Dhar has spoken about the implementation side of it, what are actually the trends suggesting with respect to product patent? Like what are they saying about the state of our innovation ecosystem?
I'm a litigating lawyer, so where I see a lot of action is court, and I will draw in from my experiences in court and how, at least from my point of view, what that indicates in terms of innovation in our country. But before going there, how do we measure innovation in our country? Of course, there's a raw metric. How many patent applications are being filed? I think everyone is agreed here that a lot of patent applications are being filed. What are they creating in terms of value is a different question. We don't have enough output in terms of valuing what that output really is. So I guess, yes, number of patent applications are increasing. Number of patent applications by Indian applicants are increasing. For the first time, we celebrated more than 50% by Indian applicants. So it's an upward trend. Now, what does this result into? To my mind, often is the case that the value of tech at the time when it is applied for and when it is realized, there's a gap. And I see this on the licensing side a lot. When you want to license your patent pending application in a market where you do not have protection today, there's a lot of reluctance in terms of how much you will get for it, because you have no exclusivity on that date, and there's a risk. What if you get a patent after, say, in the 18th year of your application, right? And here's somebody who took a license for a very long time, and technically you could be entitled to back damages from the date of publication. Practically, will you get it or not is a different question. So here are all the reasons why it's difficult perhaps to value the tech as on date you have applied for your patent application. So in this sense, we don't know how much value these applications are generating. But to my mind, there is a sense that innovation leads to economic growth in a country. And why do we say this? We have seen this model play out in other parts of the world, and perhaps we are trying to emulate that model that has been successfully played in other parts of the world. Back in the day, we're talking about 2005, pre-2005, we were not looking at India as the innovation hub in the sense where we wanted to be the country that would maximize the gain out of a patent system. We were defending. Now we are going on the offensive in a way to say, let's maximize what we can get out of this system. Now with that view in mind, if we want to maximize the output, and I'm not talking about any specific industry, or I'm not talking about pharmaceuticals specifically here. If you want to maximize this output, to innovate and to get a product ready to market that succeeds is incredibly hard. And this is not any one industry. I hear a lot in the pharmaceutical sector, it's exceptionally hard and it's exceptionally expensive. I'm parking that. Any industry, or even a small startup, I work a lot with young companies, if you want to create a product which actually qualifies as an invention and you want to take it to market such that you actually earn money from it, doesn't happen easy. In fact, it doesn't happen to many entrepreneurs for a large part of their lives, or for their entrepreneurial journey, they quit because they fail. So it's not easy. And if your system rewards you, there has to be value to that reward. You should be able to maximize it. Otherwise, if we are going to maximize, if our intention today is that we want to use this system as a developmental, step towards a greater journey for advancement, we won't achieve it. And failure is such an innate part of innovation. And it comes at a huge cost. It comes at a huge human cost. People change goals. You can't keep sustaining this failure after failure journey. It's not possible. I know so many friends on entrepreneurial tracks who lose faith because they have lost so much. So all that goes out. The 1% or limited minority that succeeds does want to maximize the benefit that they get out of it. Now with that in mind, to my mind, it does make sense to have a robust patent enforcement regime, because at the end of the day, how do you exploit your patent grant? You license it, you commercialize it. And how do you commercialize it if everybody else can infringe? Then what's the value that gets reduced? It gets drastically reduced. So I think it makes sense, if our objective is to maximize the exploitation of this system, then it should be a robust system. Is there a social cost to this system? Which is why we have checks and balances here. And because I see it from the litigation lens, I do view our courts as the entities or the regulators of this balance to a large extent. That's where we see a lot of push and pull of rights and obligations play out. And that is where a lot of balancing happens. In terms of practically how much innovation is happening by Indians, we have started seeing Indian companies litigate for patents. That did not happen in the past. So it's not true. There is. So in terms of the patentees we see in court now, there are smaller companies who have, for example, created a new way of manufacturing, say, some sort of storage solution. They are enforcing their rights in court today. There is one litigation which involves an Indian innovator who has a solution that applies in the telecom sector. So these kinds of litigations have now started coming to court. Are they the majority of the patent litigation we see today? No. That's not the case. But we are seeing more and more Indian companies trying to maximize their IP, especially in the patent space. So I don't know the value of what these patent applications are translating to, but the sense you get by seeing at least some of the litigations in court and some of the patent filings we are doing and interacting with people in younger companies and how they view this, it does seem like everybody does want to maximize the benefit of a patent grant.
So in that case, then, so if we look at, let's park the value question and come back to then looking at what is the present system looking like. Do you think we need more reforms to keep up with the changing times and the kind of technological advancement that is happening, considering you were saying that the difference between by the time tech comes in and the patent comes in and the gap that it creates?
Right. So we have been criticized a lot about speed. In terms of how long the journey of a patent application is from filing to grant. And there are amendments that have been introduced to cut that down. We will not see the result of these amendments immediately. So my sense is that there have been steps taken. So for example, your request for examination, the period has been reduced. So we'll see in the years to come, maybe couple more years, 3 years, actually 3 years or 4, something around that line, we'll be able to see how much these reforms are really impacting. Anything that reduces the time frame from filing to grant is a direction that we should consider, provided we're not compromising on other checks and balances that are there in the process for a reason. So that's a lot of criticism our jurisdiction gets internationally. The second aspect, I think, is, and I don't know if this is something we should do ex ante, but we will see an impact of new technologies in the process of innovation. So for example, if artificial intelligence, the greater the role it's going to start playing in the whole innovation process itself, we will see it interact, and we are starting to see it interact in the patent, what qualifies, what doesn't qualify, how does it define incremental innovation, the role that AI may play in incremental innovation. In fact, how do you define the scope of claims when you apply applicable technology? Because how much is undue experimentation is changing, right? So what undue experimentation could have meant, say, even 5 years ago is a very different yardstick today. So these are going to be challenges that we'll see. We are seeing some litigation on this front, but not in the patent context, but in the copyright context. But I do sense that this is a direction where we may likely play catch up.
Again, yes, yes, the pacing law that we call about. Yeah, thank you for that, Ms. Nautiyal. Given that, I would move on to Ms. Rao, because we have been talking about the patenting system and the value that it brings, and we also go on to say, like Dr. Dhar was saying, that our patent system reflects the rights of patent holders as well as balances out the public interest side of it. I would then like to ask you, do you think the introduction of product patent regime has actually led to achieving social justice? Because that was also one of the intent, at least when we were moving towards being TRIPS compliant.
Thank you very much for inviting me to this distinguished panel. And as we touch upon this very important point of 20 years of product patent. So I think it's a pivotal shift, not only because it's changed the pharmaceutical landscape. I'll talk from the pharmaceutical perspective, because I think this 20 years has had a lot of profound impact on the pharmaceutical industry as well as the lives of the people. So, and also I think it has changed the very essence of how we define health equity, global, like the essence of what we talk about equity in health purposes. So I have had a gamut of experiences. I've worked with consulting firms, I've worked with the innovator pharmaceutical companies, with generic pharmaceutical companies, and then today I speak from a civil society's perspective, from a patient's perspective. For people, for patients, and for people from this part, patents are not just constructs or legal abstracts. They are actually lifelines of survival. And I think at many places, I may say, there are barriers. So in one way, 1970 Act was quite constructive because, as Professor Dhar just said, they spurred innovation. They brought India to a position where we are today, known as the pharmacy of the world. We saw the prices of the drugs being plummeted to more than 98%. We actually helped to combat the AIDS crisis, HIV/AIDS crisis, by supplying low-cost ARVs globally. But then we saw this winds of globalization coming, and here we are today, 20 years down the line, asking this question: has it actually achieved social justice or equity in terms of public health? From a civil society perspective, I say my answer may be very laced with resilience, triumphs, and I think a lot of shadows of inequities in global health. So, and also especially in the Indian perspective, I may say, because if you look at, it was meant to spur innovation. It was meant to bring a lot of foreign direct investment into the country. It was meant to innovate us technologically, provide us a lot of jobs. And at the end, all of this, the product patents in pharmaceuticals were meant to trickle down to public health. The cost of human life has been profound. So you see, it's generally seen that we got the shock when this came because we saw the prices of drugs being very high. Today also I was talking to her and we saw the prices of oncology drugs which are skyrocketing. And then at the end of the day, what we see is, this is not just like, I'll give you a couple of examples and I will not shy up on taking the time because these are real life instances. We know India is the 4th largest country which has the lung cancer cases in the world. Every year we take close to 80,000 cases. And if you look at one of the greatest drugs that has been produced to date for lung cancer, and it's Keytruda. And if you look at the price of that drug, it's anywhere above 50 lakh rupees for a person's treatment across just 1.5 years of his life cycle. So a lot of people in the Western world have benefited from this drug, but if you talk to Indian oncologists, they will say that we know the drug has marked beneficial effects, but we don't prefer it to our patients. Why? Because nobody is able to afford the drug. Only if you look at a study that just came out, it said in India only 1% of the people are able to afford this drug, and this is a miracle drug with indications across 35 cancer indications. Nobody is able to afford that drug. It's still under the patient program, but you see a larger chunk of the population. I'll move to another set of areas. We've already seen the Supreme Court coming out with saying that stubble burning needs to be stopped because we are edging towards Diwali time, where we all know the AQI will rise to such a level that we all will be putting masks on our faces. You will definitely come to college wearing that mask. I will go to office wearing that mask. But there's a set of children who are suffering from a disease called cystic fibrosis. Their lungs are working, many of the kids, the lungs are working at a capacity of 30 to 40% only. And for those children, they are holed up inside their houses for the next 2 months. Why? Because a drug that will help them to breathe, Trikafta, is available at a price of USD 300,000 US dollars. I translate into the Indian currency and you see it's 2 crore 36 lakh rupees for 1 year. And that child is supposed to take that drug for the entire life. Now, the company that manufactures the drug has disengaged from the Indian market. It's not coming to the Indian market, neither it's marketing the drug in India. Till last month, not even a single unit of that drug came to India. But they have not disengaged themselves from the patent system. They've filed multiple patents on the drugs, secondary evergreening, protecting every possible angle of the drug they could protect, but they have not bothered to get it even to one single patient across. Patients, advocates went all the way to Boston to talk to them that please bring the drug to India. They were ready to bring the drug to Nepal and China, Sri Lanka, but they were not ready to bring the drug to India. So this drug has a lot of patents in India. We mapped 18 patents on this drug in India. This is not one anecdotal example I'm talking about. There is another drug, Risdiplam, which is for children suffering from spinal muscular atrophy, which is their lifelines because it hinders their movement, it allows them to move. The drug from the innovator costs 6 lakh a bottle 1 month. And one of the Indian generics manufacturers is ready with their drug, and the price is just 15,000 rupees. But the innovator has stuck that case in the court, and it's our generic manufacturer is in a legal battle for this drug. It's not reached the patients, the generic version of the drug. So everybody who is into this program has to pay 6 lakh per bottle. That is what I just said. This is just not one anecdotal example. It's a systemic failure. It's a big failure because innovation has led to exclusion, especially in case of public health, in case of access to medicines. So we had a lot of bulwarks in our patent system. We had Section 3D, where we did not allow a lot of, luckily for this lung cancer drug, we have not allowed secondary patents. But as Professor Dhar was telling, in a study it was found that the Indian Patent Office has granted more than 80% secondary patents on a lot of drugs. And then we also had compulsory licensing, which was like one of the main centers of the TRIPS agreement, where it was said that countries can use it to protect their public health. We've only used it once. And we've not, after that, it's gradually atrophied.
Is there a reason for that, where because when we talk about the flexibilities that the patent system introduced through these amendments as well, we talk very highly of it. Yeah. And also the general understanding is that India is using flexibilities in a way, which is why we continue to be called the pharmacy of the world. So how much is the truth in that statement, and how is it like actually panning out?
It's no longer the truth anymore because we're not using flexibilities. Or compulsory licensing was only used
Yes.
once in India. And it is ironical. We are always placed on the US watch list as a
Right.
priority country to be watched out. And who's the one who produces it? It's US. It's the harbinger, and it's ironical, the situation, because in COVID-19, US itself issued 62 patents, compulsory licenses, and we did not issue even a single one when our patients were grappling to get the medicines. So they issued, and there is a study by Knowledge Ecology International where it is clearly shown that US itself issued, but then they go after countries, developing countries like India, that we are faltering on public health, we are faltering on TRIPS compliance. So this is the dichotomy of the situation, that we are not using it. Come to the free trade agreements. And in free trade agreements, there was something which was called as, we've gradually atrophied our policy space there. So earlier we used to have there was this document called Form 27, which was instrumental. It was the most important document that helped to secure that patent, the first compulsory license. What is Form 27? Form 27 used to be submitted by the company, the patent holder, where they used to say that what amount of drug has been imported into the country, how much product has come into the country. And after the 2000 amendments, and especially after the EFTA India trade agreement, we made, last year, we've now made it from, it was to be filed annually, and it was a very pivotal instrument in the hands of civil society people and patient groups and everyone to negotiate with the company that, look, you are not bringing the drug with India. In fact, when I am talking about this 1 unit of the drug for cystic fibrosis, the data also comes from Form 27, that none of the units, like minuscule number of units, have come into the country. But what the amendments did was that now, in place of annual filing, it's now moved to triennial filings. So the company is now allowed to file it in 3 years. So now we have to wait for the data to come after 3 years, and all this is ease of business. So I think, concluding, I will just say that we all are talking about a lot of patents are being filed, lots and lots, but nothing is getting translated to public health.
Right.
So I think this grand tapestry that we are trying to weave of innovation, of development and everything, I think patents should probably be only threads of progress. They should not be knots of despair that it is at the moment for patients suffering from diseases. You know, this is a carnage when anybody in the family suffers from cancer. I was just talking to her. It's humongous, the burden. We saw the report from Rajya Sabha where it was said that 50% of the families have to mortgage. Its financial toxicity that results. And I am not going to rare diseases at the moment because the
Yes.
situation there is like a mess.
Yes.
So it's much, much worse for rare diseases. And for cancer, you're mortgaging your houses, you're rationing your food, everything is there. I think when we talk about 20 years and we reflect on this, I think true equity comes when patents actually translate into patients. I think priority is patients, public health, and not just profits. So I think the legacy that we have owned as a pharmacy of the world will just be luxury going forward if the way things are happening. Thank you.
Thank you, Ms. Rao, though a very bleak picture of where we stand with social justice with respect to patents. But I would still like to know from Ms. Shah on how are the startups doing in this area of patents? Like, have you seen the trends change over time with respect to startups, especially in the light of government initiatives like Make in India? Do you think that has helped in strengthening the product patent system over the years? Have you seen any changes?
Yeah, thank you very much. Yeah, thank you, ma'am. So here I will not touch about the product patent. I will touch general, what I have seen. Working with the lots of inventors and lots of the universities these days, what I have found that these days the invention is more focused with the technology based, the AI based inventions are there in the market. Everything what the inventors, what the universities are trying to get the patent, trying to publish is basically attached with the AI based invention. This trend is increasing. I have a word with Dhar sir, where I was discussing that, sir, these days what is happening, people are just going to ChatGPT and just they are getting their inventions there and just come to us that, okay, we have to file that invention. There is no quality of inventions there. If I am going to scrutinize being as a examiner of that invention, there is no quality. It's useless, but still we are filing. So there is no use. Why we are filing those kind of inventions? So rather we should focus on the area where we should actually develop the more powerful invention, more drug-based invention, more pharma-based invention. Though I know it takes lots of time to develop a new pharmaceutical invention or the API or the molecule, but since these days the quality of patented inventions by the government universities or the universities is very less. So the trend has been shifted. Because why it has shifted? Because the government has given lots of initiatives. The first is the SIPP scheme, which everyone knows. It's for the facilitation scheme. The intellectual property is being facilitated. They are given the incentives for filing the patent. So that's why the junk filing has been increased. Though it has been increased, the second one I will touch is the MeitY scheme for the electronics one. MeitY schemes are there, SIP-ET schemes are there, which is basically for the filing of an international patent application in terms of the electronic and the telecommunication invention. There I have seen that people, though in India, Section 3K is there, which prohibit for the software invention. So now it has come into the judgment by the Madras High Court that if we are integrating the software to the hardware part, then we are able to file, we can secure our invention. So as soon as this judgment came, suddenly we saw the increase in the innovation, increase in the invention, which they are just integrating it the hardware and just coming to us that, okay, there is a hardware, there is a software, just file the invention. So this is how we are dealing with the patent, means the universities and the startups also, they are individual inventors also, they are also doing the same thing. So the second is the SIPP I have mentioned. The third is the NIPEM. The people are getting aware. Means NIPEM, because of the NIPEM, the startups are getting aware that, okay, these are the schemes which are government facilitated. We should file along this. We will be getting incentives for that. And this is the best impact of the Startup India. The fourth is that the expedited examination and the fee reduction, what Dr. Pandit told. Okay, there's a 50% reduction when a startup company comes and file the invention. Nowadays, what's happening, the startups are coming, they have one female inventor along with them. Because of the female inventor and the startups, it's like that they are eligible for the expedited examination. So though after the expedited examination, the duration gets less and we are able to file the lots of patent application. So I think that there are lots of initiative which is taken by the government for filing, for encouraging the startups to file the application. But I think personally, as I'm examining lots of patent examination, that there should be some quality of innovation should be there. We should not focus on that, okay, 1 lakh patent we are granting in one financial year. This should not our goal. Right now, what happened this year, it's only 50,000 application has been published and lots of pile-up is there. No office actions is there. We are waiting the controller to, means the patent office to clear the office action. So why this time in the 2025 there is less invention? In the earlier 2024, 1 lakh invention you have granted. Right. No use. Means right. It's not of a use. So it's means I'm facing the challenge as being an examiner. So I think we should work on this. Right. And
so I just have one question based on what you were saying about women entrepreneurs or women as inventors in application. Have we actually seen a rise in women being inventors, or do you think the government scheme like the expedited timing of the patent application leads to women coming in as co-inventors?
Yeah, this is a very interesting question. Means couple of months one startup came to us. Okay, so they were like a male colleague. They came to us that, ma'am, I have to file the patent application. This is personally I'm doing. Then I came and said, okay, you are a startup. So means, do you have any female? Though you are eligible for filing do you have any female? At that time, they don't have any female inventor. Suddenly when I asked that, okay, do you have any female inventor in your system, or some female who has contributed, then suddenly the other day he came, okay, ma'am, just this is a female. I was like, I asked that ma'am also, ma'am, have you contributed to this innovation? She said, no, ma'am, sir told me that being a female inventor, I will get the benefit, so I am here. So means we are facing. This is general to general facing. I usually talk to them that, ma'am, at least you should contribute. If in a patent certificate you are getting your name, you should have the idea of your invention, what you have done. No, ma'am, they said that, okay, if you are female, just come with us. That will be expected. So this is a challenge.
Right. So I believe that the gender challenge remains when we talk
Yeah.
IP in different categories of IP work, not only restricted to patent, but one of the major critiques has also been over the years that irrespective of how much we have gone ahead with all these patenting system, we still don't see enough women inventors. And clearly, I don't think the government scheming helping in coming over that barricade. So I will come back to the last question for this session, back to you, Dr. Dhar, where we started. So considering all that has been said, where do you think this adoption of this product patent regime has taken us over all these years, if you have any concluding remarks?
No, I think, as I said, that the product patent regime was supposed to provide an incentive to the entire innovation system. But the problem is, like I said, that if you just have a strong patent system without an efficient innovation system, and the innovation ecosystem is really, sort of struggling, then you actually create a whole lot of distortions. And that's what we are hearing from, the other panelists, that you would have bad patents. These are not good examples of good patents. And this is a practitioner saying it. We actually looked at the patent documents and found that. And she's actually giving an example. Chetali is actually midway. She's a practitioner and a researcher like me. And she's also, been doing that. So, and of course, it's very difficult to actually give a very clear, make a clear conclusion as to what has happened because of the product patent regime. Yeah. We haven't been able to, of course, one thing is very clear. We haven't been able to incentive or even, take our innovation ecosystem to a different level. We haven't been able to do that. That's for sure. And I think wherever we look at it, this is something. Now, one thing I must add here, and this is from her discussion on licensing issues and the costs and all. One fact that is there in most developed countries where innovation actually drives those economies is the contribution of the government. The government actually makes, it's not up to the innovators or inventors to put in their hard cash to get the patent and then make it run. It doesn't happen that way. The governments actually come up with big funding and then give a lot of assistance. Just give you a small example. We had the three major COVID vaccines. One was of AstraZeneca, then we have the Pfizer vaccine and the Moderna vaccine. Now, all these three vaccines were produced with huge amount of taxpayers' money. In fact, the Moderna vaccine, the public interest group said that it should be called people's vaccine because it's almost entirely funded by the state. Yeah. So wherever innovation ecosystems have, and our own research actually shows that in many cases we've seen that almost 60 to 70% of funding in the research actually comes from the government. And the companies do what they're good at doing. They actually commercialize it upfront. But the entire risk-taking, most of risk-taking is done with government funds. So a lot of problems that you're talking about, those disappear in all these countries, advanced countries, and China is now following suit because of the government involvement. And the government here refuses to do anything. And we are discussing before, during lunch, that all these nodes need to be connected, university, industry, even the government labs. The CSIR system is a huge network of research institutions. Yeah, all these nodes need to be connected by the government through conscious funding and proper initiatives to see that all these useful technologies are actually come to the market and they're commercialized. Yeah. Now, why should I feel extremely pained. Again, as I said, that I've been looking at these innovation issues for several decades. That India still is talking about technology transfer. We go with a begging bowl. With wherever you go to climate change negotiations, I've done it there. We say that without technology, we really can't do anything. We can't do any climate mitigation.
Right.
Please give us some technology.
Right.
Now, who's going to give us technology? Once I remember, was in a panel in Geneva. I was talking about technology transfer. So there was a person from a Swiss, from a Swiss company sitting next to me. So after my presentation, he nudged me and said, "What are you talking about technology transfer? Now, who's going to transfer technology? Technology is actually owned by companies. Huh?
Right.
And you are coming and saying government should actually do technology transfer? It can't happen. You should talk to the guys who actually do technology transfer, that is the companies.
Right.
And find the better ways for them to transfer technology to you.
Right.
But we are not doing that. We go to the international forums, here, there, everywhere, and just talk about technology transfer. So I think we are actually missing the woods for the trees. Yeah, we're talking about numbers of patents. We are not talking about identifying the useful patents that are there. We are not like she said that we are not ensuring that there is this quality behind the patents, and we are just gone to a numbers game. So I think it's very important to understand that patents system can succeed when the innovation system is actually thriving.
Right.
Because like he's given the sword example, I'll again use the sword example. It's a double-edged sword, not a single-edged sword.
Correct.
So it just depends on which side of the sword you are. Are you on the cutting side or you're being cut? Yeah. Unfortunately, today what has happened is that we are in the side where we are just seeing ourselves being cut because of what Chetali said.
Right.
That we are at the receiving end. We are seeing prices of medicines just go
Soar.
up like mad.
Yeah.
And there is no remedy inside. So I think there's a lot of reflection that we need to do, and I think the young students here also need to see that how law and policy, they are working in tandem. Yeah. So you cannot have a good law if it's not backed by effective or proper thinking about what the policy should be.
Right.
And patent system is supposed to spur innovation and to bring in a more competitive regime of innovation. What has unfortunately become, what Chetali's example, that there are some gatekeepers, in pharma I know, that are 7-8 companies, major companies, who are trying to sort of block the entire innovation system and keeping the entire thing to themselves, not letting the new players to come into the market. I think we need to think about all these issues really, very seriously. Thank you.
Thank you, Professor Dhar. I would now like to open it to the audience for questions. In the interest of time, I request that the question be precise, and please also let us know who do you have a question for.
And the name of who's asking the question.
Yes, please also introduce yourselves briefly. Anyone, any questions? Could someone pass a mic there?
Let me say at the beginning, Saraswathy, if there are no questions, then that means that we have been so convincing.
Perhaps we would.
Or we've been completely dumb.
I know. I would believe the former. Here, this side.
Hello everyone. I'm Deepak Kumar Swamy, founder of SciTech Industries. We are building industrial IoT solution. So we are working on both hardware and software side. And we are working on AI-based predictive maintenance solution that is being deployed on the S side. So yes, we are building a complete solution integrated solution. So we are at initial designs of our first PCB design. We have deployed one MVP as well. So I would like to ask, when would be the right time to actually start applying for provisional patent?
Thumb rule.
Yeah.
Apply pre-launch.
Okay.
I think for patents and designs, and this is something that I guess should be introduced very early for anybody who is going to think about commercializing IP. When you apply for your IP is sometimes so important for certain facets of IP that if you miss that, you do not end up getting the IP. So as far as patents and designs are concerned, these are pre-publication applications, meaning you should not disclose your patent or your design to the world before you apply them, and that's the logic of why this system has come into place in the first place. You will get a patent only if what you have is new. You could self-publish it, and therefore it won't remain new. So you have to decide at what point is your invention in this state of readiness, where you are ready to file a provisional, but it has to be pre-launch.
Yes, as we are adding certain sensor integration and different features on day-to-day basis, so I'm still not able to decide like if you would go with the provisioning patent once our this PCB design is done, or we should do some more testing and then we should move forward with that.
So the way you want to assess this is, what do you think is actually your inventive feature?
Okay.
If you already have your inventive feature and you've identified that this is what is truly novel and this is what is different from anything that has existed before, and this is what you have done, and then yes, you will tinker it and you will add more things. But your inventive feature, once you've identified, that is when you should apply for your, at least file a provisional. Because once you convert your provisional to a complete spec, it will still have to be substantially based on the provisional. So your provisional has to identify what is your inventive concept. Once you have that, you're ready. But if you don't have that yet, if you think you're just an amalgamation of different pieces coming together, etc., you perhaps may not be ready to file for a patent so far.
Okay. Thanks.
Yeah, absolutely. I think, see, there was a time when, in the scientific world, people used to say, publish or perish. Today, it's patent or perish. Yeah. So the first thing you must do once you get this is, and then you keep developing it, because see what she was also saying, that there is a certain time lag between the application and grant. Yeah. So, that's what the companies do, that right at the beginning when they see that there is a spark somewhere they see, and they know that this is an inventive step. Yeah. Novelty is an easy step, but inventive step, they've got it.
Correct.
They apply and then keep developing it later. And then by the time you're fully developed, then you get a patent and then you market it.
Do we have any other questions?
Thank you so much for the wonderful talk. This might be a very naive question, or might appear as a very, very naive question, but do you really think that patents are the only drivers of innovation? Why so much emphasis on patents? I mean, there have been plenty of historical examples where non-monetary incentives have also been drivers of innovation, and they've actually been used for public welfare. So, I mean, in a capitalist society, obviously, there will be emphasis on patents only, but why don't we try to break out of that discourse also? One of the controversial examples being the Soviet Union, right? I mean, they had non-monetary incentives and there were innovations. So what do you have to say about that? And the other thing being that, as much as we talk about innovation resulting from competition, patents also lead to monopolies, right? And that's something that we're discussing. And also, I mean, one of the other things being whether the money that comes in from the patents, is it really used for further innovation? No, because I mean, there have been plenty of examples, specifically in the pharmaceutical industry, where most of the money that comes in through patents is actually being channelized into marketing, not really further R&D or innovation. So whether patents really spur innovation, I think that's a very, very contested claim per se. So yeah, I mean, these two questions, whether patents are the right motivator and the other one.
Yeah, see again you say that, we are firmly in a market economy. We are not in the Soviet world. And in a market economy, you see the major thing is, the key thing is that you must have proper incentive system mechanisms. Yeah, and like I said, I gave the example that suppose you are in a free market, like even in a knowledge economy, you have a free market. You don't have a patent monopoly. You haven't actually created a barrier to access to technology. Then what happens? Yeah, then investor is putting money, yeah, and develops a useful product. Immediately after it's known, now we are talking about the timing of patenting. But suppose you don't have a patent system and the product or the process comes into public domain, immediately someone is going to pick it up, or tens of people are going to pick it up and start producing that. Yeah, so which means that person who actually put in the money for investment has no incentive to go any further. Yeah, so the innovation system gets killed. Yeah. This is something, Kenneth Arrow, famous Nobel laureate, he actually said that in the first instance, that you need a distortion to be introduced in the market. So this is the only market where a distortion is deliberately put. Otherwise, you are removing distortions from everywhere. Yeah? Talk about, international markets, you're talking about domestic markets, you're removing distortions. But this is a distortion you are placing in public interest, because you want the public to be, getting more innovations. That is the purpose. Yeah. Now the question, you're right. There is also, this is a contested issue, like you said yourself, that whether a patent system is the ideal instrument for producing more innovations. Or do you do it, like the way all the other things happen in a market economy, have a perfectly competitive market? Yeah, and market competition actually produces more innovation. Yeah. Now, so this is a perennial question economists have been asking. And why? Again, you gave that answer yourself, that patents create monopolies. Yeah, and monopolies have deadweight losses. So the patent system creates monopolies. Of course, the American courts, if you ask, I mentioned also that they are not in agreement whether patents create monopolies. They say that, look, any product which is under patent, it has substitutes. Yeah, so you can actually don't go for that patented product, go for substitutes. But like Chetali gave that example, yeah, the substitutes are inferior, they're less efficacious, so it doesn't make a sense. And also, look, the pharmaceutical, giving an example of pharmaceutical, is the only market, I think, where the consumer is not free to choose. Yeah, we are not like buying a toothpaste. We are actually taking a medicine which is prescribed by a doctor. So you can't go to the doctor and say, look, I don't want a patented medicine. It is high priced. Please give me a unpatented or various things, substitute. So the doctor will say, if you want to cure us, get yourself cured, then you have to take this. So therefore, the consumer is not free to choose. Yeah. So you're back in that world of monopoly. So this balance, there is a very interesting study by a pair of American scholars, and they said the book is called Against Patent Monopoly. Yeah. So they've argued that patents are not required for for innovation system. Yeah. But I would say that I won't go that far. I would say you need a patent system because you need some incentive system. Yeah. But like I said, that you must balance it. Right. Yeah, you must ensure that they do not become, overbearing monopolies. Yeah, and they do not actually run away with the public. Yeah, the public interest. So this is the most I think, very important public policy instrument. And the public policy instrument should not be misused, because there is no other way we can actually contest patent monopoly, because you know that all countries have competition laws, yeah, but competition laws do not touch intellectual property, yeah, because governments don't want the two wings of the government to fight with each other.
Yeah.
So our competition law says I have nothing to do with patents or intellectual property issues, yeah. So I think, therefore, it is very important that I won't throw the baby out with the bathwater, because it has so many problems. But I think we need to keep reviewing the law, not only to improve the rights of the patent holder, not only to improve the monopoly rights, but also to see how the public interest is not just access to medicines, also whether it is spurring the innovation system, whether new entrants can come into the innovation market, the market for innovation, and produce and are able to produce more innovative products. So that is, I think, the key.
A couple of thoughts to what Mr. Dhar just said. We have inherited a patent system, and because of how interconnected everything is, and the fact that it was introduced as a part of a trade agreement, unilaterally backing out of something, or starting something which does not fit into the other pegs in the world, I'm not sure as a practical solution how feasible that is. There is a lot of criticism of, is this the optimal solution? Perhaps not. But is there a better solution that takes care of all the push and pulls in the world? Is what we could work towards. The second aspect on monopolies and patents, and Mr. Dhar touched upon this, is the way the law addresses this question is that it's not that every patent results in a monopoly. And what we use now is market power. So it's not possible that every patent is equal to market power. You have to see what the patent is granted over to see whether that grant results in market power. So it's not a binary sort of answer every time, but you have to do that assessment on what that tech is, what is the scope of the claim, etc., and what the product eventually is. And the last thing about this thing about IP and antitrust, that's an interplay that has played out differently in different jurisdictions. The Indian experience so far has been very different from the rest of the world.
Yes.
In many jurisdictions, antitrust scrutiny has taken place over several issues on IP. The Indian experience so far has been what Sir said about silos. That's where we are.
Non-confrontational.
But it's still not the last word on the topic in our jurisdiction.
Right.
No, I just want to, since you said this, look, I think what you said about market power and monopoly, if you don't have market power, patent system makes no sense. You have to have market power, and that's why it makes sense. Yeah, that's the rationale. No, that's the, I must tell you here, because I'm the only economist in these lawyers. The justification for a patent system was given by economists. Yeah, and the lawyers are running away with all the money. So I think I should have. We poor economists may make no. I am not making any money. I can't make any money. You're making money. Chetali, of course, she's now come with us. Yeah. So that's it. So no, if you do not have any market power, then the rationale of the patent system actually falls flat. It is supposed to give you market power. It is supposed to. Otherwise, how do you recoup? Because then competitors come into the market. Yeah, yeah. So that's point number one. The second thing is, yes, in different jurisdictions, the antitrust and patent thing has worked differently, but that is a thing of the past. There was a time when the Sherman Act in the US was the Antitrust Act was used to break patent monopolies, but no longer. Yeah. The last significant thing that the Federal Trade Commission, which is the competition commission of the US, did was which says something about patents and innovation. And it was the best critique of the patent system that I have read till now. But then after that, the FTC has gone completely silent.
one more thing after that, at least that I know, is the reverse payment settlements.
No, it's nothing compared to that big criticism that did. Yeah? No, but yeah. Yeah, but see, the other thing that, see, they actually did some work on the pay for delays and all those things. They're doing it. But those are little things, yeah. But on the general issue of the conflict, the FTC has gone completely silent. They're not saying anything about it. And so we are all falling in the same line.
Right. Thank you so much. So if we have to take away something from this panel discussion, going to what Dr. Pandit was saying earlier about, we stand at a good point to kind of understand what should we do further if the goal as a country that we have is of Vikasit Bharat in 2047. So perhaps what Dr. Pandit said, and taking from all the panelists, I believe that there are different steps that we can take in different capacities to actually I now request Professor Davinder Singh and Professor Sonika Bajpai to come to the stage and kindly felicitate our panelists.
Nice meeting. You too. Nice meeting. I won't say this to you.
So don't pick up any phone, I go phoneless.
He left out.
Professor Dr. Biswajit Dhar. That's good.
I seem like I'm the one who's getting it.
Ms. Abhilasha Nautiyal. Ms. Chetali Rao. And Ms. Shuchita Shah. Yes, please. And maybe we can come here.
We are the only two guys on the stage right now.
Yeah, I didn't want to say that, I was a solitary guy.
We got the gender balance this time.
You got it right this time. Thank you very much.
Thank you so much. I now request Professor Dr. Prabhakar Singh from the School of Law to deliver the vote of thanks. Either way.
Yeah, finish the...
There was a lot to be said on this topic, and a lot has been said on this topic. Today we were treated with this wonderful exposition of a subject that is technical, that appears technical at the law school, but only by sitting in such a seminar would you know that this touches everyone around the world. It was for this reason that the Supreme Court of India, in its famous judgment of 2013, Novartis versus Union of India, proclaimed India to be the pharmacy of the world. And our panelists today told us that perhaps we are losing that position because the government is happy giving data, whereas the civil society is doing the scrutiny. And only by looking at both the sides are we going to understand whether the claims that the government is making are translating into useful inventions for the people. And we heard from Dr. Pandit that the government is trying to create a culture of IP, but then we have to wait and see whether that culture will lead to solutions for the people, because we were presented with facts, anecdotal facts from at least 2 industries, that we are far from that, and perhaps therefore number is not always a good indicator of quality. Quantity is not always a good indicator of quality, and perhaps on the lines of what the government wants us to do, which was presented by Dr. Pandit, we need to think of how India becomes developed India in the next 20 years. We have to think about what would development mean for us, and would development mean for us being Americans, where diseases are the issue and they do innovation, but it's not the healthiest country in the world. So then we would have to think whether this innovation or development perhaps also needs redefinition in an Indian way, if there is one. This wonderful discussion today would not have been possible but for the efforts of people from our university, starting with Professor Dr. Davinder Singh, who heads the ACIC at BMU, Professor Dr. Abhimanyu Singh Rana, who heads the IPR cell and is also the director for research at the university, Professor Maitre Singh at the School of Law, Professor Vikas Kathuria at the School of Law, Professor Sonika Vajpayee at the School of Law, and Professor Suniti Sampath at the School of Law. Our student volunteers have worked tirelessly to make this a success. Amongst them are Akshay Satyapal, Ananya Nair, Kaushika Bansal, and Suvarna Gauri Kalaburg. We have had students reporting the event, and they are Vatsalya Rajmishra, Abhideep Dhar, Pravir Sandhu, Nanika Bhagi, and Vanya. We would like to thank the communications team headed by Nigar and supported by Rubel for poster design. And last but not the least, and perhaps most important, because our in-person keynote turned into an IT supported event, we'd like to thank the university IT team for supporting it, and we were able to listen to this wonderful presentation, and then we've had this wonderful response from the panel. Thank you, everyone.
With that, we conclude our event. Thank you so much for being a patient audience.